Okay.
So, just moving over, since we've spoken about IP, Shreya, would you give a broad overview to our participants as what are the labor nuances or what are the broad labor overviews in relation to labor laws which our foreign counterparts need to be aware of?
Sure. And I think so. There's one aspect to the labor law regime that's similar to the IP regime, which is that very often the laws have been around for several years. They haven't adapted to changing times. And that's also true of our labor law regime. So I'm not sure how many of our listeners know today, but at one point in time, India had a very strong socialist bent of mind. And a lot of our labor law legislations came up at that point in time. So, if you see the large trends or the large themes that overlay these legislations, what you'll find is firstly, there's a very strong pro employee bias within the legislations. And secondly, there are certain rights which corporations may take for granted in other countries which they will not find in India. So one example of this is non-compete clauses, right? You would assume that if you have an employee who you hire, then you would be able to claim non-compete protection in relation to a future business set up by that employee. But in India, the way it works is that if you have any agreements that are in restraint of trade, then they can possibly be struck down. So what that means is that if you're looking at the enforceability of a non-compete clause, it's only during the term of the employment arrangement that it will be valid. But if it extends beyond that, then there's a possibility that it will be struck down.
So that's very interesting, Shreya. But so if I'm a foreign counterpart and I have my operations in India through
Mm-hmm.
my subsidiary, if I've shared some confidential information with the employee which he would know, or if he's on a very sensitive R&D project
Right.
and he has certain business know-hows, so how would I get or the company get protected in such situations?
So, in such a situation, again, documentation is really the crux of it. Because if you document this protection as a non compete protection, it's possible that you will not be able to enforce that before a court. But if, on the other hand, you document it as a protection for confidential information, then that is a protection that can exist even after the term of the agreement. So it's very important to know when you're getting into this agreement with this person that confidential information is adequately protected even after termination.
So documentation is sacrosanct.
Exactly. So I think the second example of a kind of provision that foreign employers often don't anticipate is that India doesn't have a hire and fire regime. So employment at will is not recognized, right? Now, where this ends up being some degree of an issue is, for example, if you have a manpower heavy business, which today most of your knowledge sectors are typically because they're very services heavy, manpower
That's
heavy,
correct.
then in a situation where you want to downsize at some point in the future, it's not really possible to do so with as much flexibility as you would have in probably Europe or the US. So that's an important thing to keep in mind while recruiting and while increasing the size of your business in India as well. Again, another related point is that there is unionizing is still fairly prevalent in India, and what you also see is a lot of industry focused unions. So this isn't just a union for a particular company or a particular group, but it's industry based, which means that sometimes they're just able to exert a lot more influence than a particular company's union would be.
Sure.
So again, a jurisdiction specific nuance. And then I think when you come down to the finer points, you find that if there is a litigation, then courts sometimes do take pro-employee views, and that's something to be prepared for. The second piece is that on a legislation front, a lot of labor laws are still state governed, right? So you'll find, depending on the state in which you set up, it's not a pan India law that's going to apply to you. It can be a state specific law. So, for example, the leave policies that may apply to your employees may vary depending on the state in which your company is set up. And I think so, these are just some examples of what to watch out for. Obviously, there's a whole lot of granular detail that that goes into setting up a business, but these are some broad red flag issues that are important to consider.
So very interesting, Shreya. So that means that, as you mentioned, there are state as well as federal labor laws. So whenever a
Correct.
foreign counterpart is having an R&D center in India, or he's focusing on doing business with an IT company or a technology collaboration, he also needs to choose a state which would be more employer friendly from that perspective.
Correct. Although, as lawyers, we tend to believe that all decisions are propelled by law, but I'm sure there'll be, of course, commercial reasons as well. But yes, if there is commercial flexibility, then it makes sense to think about the legal implications that setting up in different states can have.
Very interesting.